Welcome to Beyond the Arts, where we give opinions on disputes between creatives and companies, disputes which are in the public domain. This is not legal advice. This is just an opinion on how I would or would have approached the matter. Allow me to interrupt your episode of Rights and Rhymes because I come bearing good news. If you are looking to formalize your studies in music business and sound engineering, the Academy of Sound Engineering has qualifications that are accredited and are perfect for you. They have various qualifications in the sound engineering space, from higher education certificate in audio technology and a diploma in audio technology. You will be learning from experts in the field, and you know that your investment is protected and you will get value from your qualification. They have one of the best music business courses, which I highly recommend if you want to learn how to turn your talent into a business. Not only that, but you will be learning from this book by Advocate Nick Matsukis, which has one of my cases in it. If you want more information about how to get the book, I will leave a link down below. Contact me, I'll make sure you get a copy. And if you want more information about how to enroll with the Academy of Sound Engineering, I will leave links down below for you to check out. Their next 2026 intake starts on the 23rd of March 2026. The Academy of Sound Engineering. Go and learn how to turn your talent into a business. This is not a sponsored video. This is just us at Rights and Rhymes making sure that we connect you with the right institutions. In today's case, we look into TS Records versus OM. What is available in the public domain shows that this was a copyright infringement claim by OM. This matter was filed in the South Gauteng High Court in Johannesburg in 2010. OM, as it shows in the available public records, he submitted 3 sound recordings to TS Records with the aim of the label licensing the 3 songs as they were. OM was the sound recording owner and the composer of the sound recordings. Of course, there were other co-authors and composers in the works, which were authors of the literary works, which is known as the lyrics. What then happened from there was that OM claims that the label was supposed to choose the songs that they would want to use in their album Violence 3 and then get back to him with contractual arrangements and how their deal is going to go. Fast forward, OM submits that he then found out the songs were released without his permission as he discovered the album in a record store. In his attempt to remedy the issue amicably, he approached the label to rectify the oversight and to attend to their agreement of sharing written agreements. As you may know, in South African copyright law, there is no way that one can actually transfer copyright without any written documents. Copyright is a very unique right. In fact, copyright is one of the few rights which I call a negative right. What that means is that while all the other rights gives you the rights to, for example, the right to education, copyright does not give you the right to. In fact, it prohibits the next person not to. What then transpired is that the public records shows that the label did not respond to OM's amicable approach. That's when OM decided to approach the courts. In the background of the same matter, somehow, some way, the media got involved and the matter was now a public debate. The public records available shows that OM got a default judgment in the same court, and that's what it is. We don't have any other further records on how that went. However, one of the public records shows that the ultimate end was that both attorneys and representatives of the label and OM were said to be going to meet to try and resolve the matter. In Beyond the Arts, I try to give opinions and my views on some of the cases like this one. If you want to read more on the case, you are more than welcome to get a book by Advocate Nick Matsukis titled South African Music Law, Contracts and Business. It is used as a case study in that book. My approach to the matter in this day and age would be the same as how it was done back then. One of the fundamental differences is that back then, digital releases were not a thing when it comes to South African urban house music. This means that the only form of distribution, or the most popular, was either vinyls or CDs. In this case, Violence 3 was in CD format, and for one to really challenge the distribution of such, he had to go through various channels outside the courts. For example, you had to reach the licensing company, which was handling the label's distribution, and you had to raise your query with them about the infringement. Secondly, I would avoid, as a composer, to give any party full sound recordings for them to pick the ones that they want to use without any written documentation, or I would just give them samples of about 30 seconds to a minute to explore and to pick from. And once they choose, only then we could then give them the full sound recording after the paperwork was explored, signed and executed. In this day and age, that also might still be a red flag, because with the digital age of AI and the fourth industrial revolution, a person can remake, reload or adapt your song just from a 15 seconds clip and make their own song. So the dynamics have changed and shifted as compared to back then. However, the approach of going to the courts by OM would still be the same in this day and age. Even though the courts are expensive, amicable resolution was the best approach to try and resolve the matter internally. The next step after approaching a licensing company, which was CCP-EMI, you would then raise the issue with them of such an infringement to say, you are distributing music or a project that entails my music, which you guys do not have rights to, or anyone for that matter. This would then mean the licensing label will then have to contact the record label to make them aware of the submissions by OM. The record label will then have a responsibility to reach out to OM to try and solve the matter, or to decide on what to do going forward. Either they call back the distributed CDs, remove OM's songs, and pay him for whatever number of copies that were already sold, and then they remake and reprint a new CD and album without OM's work, if that would be the case where they don't agree on the fee or the settlement. In actual fact, in South Africa, because this case happened in South Africa, we are meant to have what we call the Copyright Tribunal, which is meant for copyright disputes and such matters to avoid overburdening the courts with matters that can be resolved quicker. In this new age, the first approach on a similar case where someone distributes your work without permission would be to issue a DMCA copyright strike. What this does is that you then contact the distributors of the work or the digital stores. Apple has a platform where you can report such an infringement of your copyright, and they will consider your submission, get back to the other party who uploaded your work, and then decide on what to do with the work. It's either they take it down or they reject your claim. The same for Spotify. You can issue a takedown notice. Spotify will consider the submissions, then decide if they strike it down or they get back to you to tell you any other reason outside taking it down. In this case, OM would have to also go to the record label or the aggregator of the company, where he then advises the aggregator to say, you are distributing music that you guys do not have rights to. And as such, I am submitting this as a formal grievance for you to take down the distribution account to me and pay me whatever you have collected using my work. Where there is resistance from any party that distributed your work without permission, you then hold the right to approach a forum like a court, where the risk is higher for the distributing party because now there might be damages, whether punitive or otherwise. Remember, any person who uses your work without permission is infringing the Copyright Act as amended. In this digital age, the approach remains the same, with the fundamentals of digital and AI implications in the case. However, a takedown notice will be key, claiming damages and also claiming the monies that were already generated with your work without permission and to be paid over to you. This brings us to the end of today's episode. Remember, know your rights, protect your rights. This is Beyond the Arts. See you next time.